Good morning. You are Stephanie Gay.
Yes.
Ms. Gay, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you now. Okay.
On January 31st, 2025, at approximately 1:34 a.m., officer observed a vehicle fail to signal a lane change in Harris County, Texas. The vehicle also had unconfirmed insurance. The defendant was later ID'd by Texas driver's license, and upon contact, the officer observed slurred speech, red bloodshot eyes, and a strong odor of alcohol emitting from the defendant's breath and person. The defendant admitted to consuming 3 beers. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues were observed on the walk and turn. 3 out of 4 clues were observed on the one-leg stand. The DIC was read to the defendant, and the defendant refused a breath sample. A blood search warrant was signed and executed.
What did you say the stop was? I missed it.
The stop was for a failure to signal lane change, and then the officer ran the plate and saw that the vehicle had unconfirmed insurance.
Okay. Ms. Gay, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail.
Judge, would you consider an analog for this case?
I am, because she just had one that was dismissed. So I am now placing a restriction on your license. You're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle that doesn't have one, I'm going to put you in jail. Do you understand? Now, you have a great lawyer listed in Mr. Darvish, and he'll tell you when you have to come back to court because you have a lawyer. I will waive your appearance, but it is your responsibility to stay in touch with him. Do not pick up any new cases. Don't drink. And if you lose your license between now and then, you're not allowed to drive. Do you understand?
I do.
Right. The other thing is also a condition of your bond is you're not allowed to drive unless you have liability insurance in your name. Do you understand? So if you drove here today and you don't have liability insurance, you can't drive. You understand?
I do.
All right. So I'm going to have you sign a receipt. Victoria, we'll have you get Fleischer for your bond conditions, and then you guys are free to go. All right. Thanks, guys.
Right, Judge, next is page 3. Chino, come on up.
You, Mr. Chino. Good morning, sir. Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 30th, 2025, at 5:48 p.m., an officer observed a vehicle in Harris County, Texas, traveling at a visibly high rate of speed in a 40-mile-per-hour zone and drive through a stop sign without stopping. A traffic stop was initiated. The officer observed glossy eyes, slurred speech, and relaxed, giggly behavior. The defendant admitted to drinking a glass of wine prior. SFSTs were conducted. 2 out of 6 clues were observed on the HGN test. 3 out of 8 clues were observed on the walk and turn. 3 out of 4 clues on the one-leg stand. DIC was read, and the defendant blew a .000. A blood search warrant was signed and executed.
Did you say that he had a strong odor of alcohol and breath, bloodshot eyes, slurred speech?
So he had glossy eyes, slurred speech, relaxing, giggly behavior, and before that, and then he admitted also to drinking a glass of wine.
Okay. I'm going to find probable cause just for now. Mr. Chirinos Tercios, I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
Yes, Your Honor.
Any prior DWIs?
No prior DWIs.
Do you see if he has a valid Texas driver license?
The driver's license is out.
As long as you have liability insurance in your name, you may continue to drive. You need car insurance. If you don't have car insurance, then you're not allowed to drive as well. That is a condition of your bond. You have a lawyer. Because you have one, we will waive your appearance. So you don't have to waste your time coming to court, but you must stay in touch with counsel and he'll tell you when you have to come back to court. Just don't drink, don't use illegal drugs, and you'll be fine. All right? I'm gonna have you sign a receipt of Victoria. We'll have you get with Fleischer for your bond conditions. After that, you're free to go, guys. All right?
Thank you, Your Honor.
Right this
Thank
way.
Thank you.
All right, Judge, next is case 4. Dickerson, come on up.
Your Honor, Mr. Dickinson is having an issue with his car. He's already checked in. Can we have 5 minutes?
Absolutely. Just whenever you're ready, come up and just let us know.
Thank you, Your Honor.
Yeah, take your time. No rush.
Judge, you're welcome. Next is
Hey, Luis, what's up, man?
page 6, Gomez. Come on up, Judge. There are 2 other co-defendants.
Where's Mr. Clay? I thought I saw Mr. Clay.
Not yet.
I think, did Mr. Clay step out?
Clay,
Eric Clay, the lawyer. He's representing the show.
do you want me to see if it's out there or move on to a different?
Yeah, since he's here, I don't want to go. I mean,
Okay.
is he representing them all? Do you know?
No, Judge.
Oh, Mr. Clay.
Call up.
You ready? Come on. in. That's okay. So let's do the other ones as well, since they're co-defendants, right? Kasim, come up. Rios, come up. Oh, Brent, that's yours. You have one. All right. So Brent, this is your gentleman here?
Mine's gonna
That's yours. Okay. So you are Mr. Kasim?
My attorney, yes, Your Honor. My attorney will be running a little late.
Who is your lawyer?
It's the Sadie law firm. He should be coming.
Let me see if I see any admins. It's Yashin. See if I have his phone number. All right. Well, I called him. He didn't answer. So you all are here. We're going to do probable cause. Each of you are charged with racing on a highway. Who's Carlos Gomez? You're Carlos Gomez. Mr. Gomez, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. Mr. Kasim, you are charged with racing on a highway and you are charged with unlawful carrying of a weapon. On the weapon case, you're facing up to a year in jail and or a $4,000 fine. On the racing, up to 6 months. As you, Mr. Rios, you're facing up to 6 months in jail and or a $2,000 fine on the racing case. Gentlemen, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay?
On February 1st, 2025, an officer who was part of a plainclothes traffic crimes task force was near Cross Timbers and East Texas Freeway in Harris County, Texas, where there was known to be a large street takeover group meeting. Officers in plain clothes were conducting a surveillance of the group of cars known to conduct the takeovers. The officer followed members of this group, specifically a gray Camaro, a white Camaro, and another Camaro. Officers witnessed the 3 vehicles slow down to 50 miles per hour and accelerate simultaneously up to speeds well over 125 miles per hour in order to outpace each other. Plainclothes officers were able to keep these vehicles in sight until marked patrol vehicles arrived and conducted traffic stops. Officers pulled over the vehicles and made an arrest.
So each one of them are in cars lined up?
Yes, Judge.
Okay.
Lane 1, lane 2, and lane 3.
Okay, so tell me about the gun on Mr. Kasim's case.
I'm sorry, guys, what was the?
So Kasem is Kasem. While you're looking at, gentlemen, I'm going to find that there's probable cause to go forward with the case. I'm going to tell you now, living in a city as big as Houston without the ability to drive blows. And I am now ordering you as a condition of your bond not to participate in these types of activities anymore. Racing, street takeovers, donuts, reckless driving. If I find that you do, first thing I'm going to do is I'm going to put you in jail. The next thing I will do is I will take your ability to drive away from you. Do you understand? Not only that, the Texas legislature has made it extremely easy for DAs across the state of Texas to seize, take cars permanently for people who are continuously participate in these activities. And I'm telling you because I've seen it here where people get their $80,000 to $100,000 car seized and taken, and they don't get it back. Do you understand?
And Mr. Kasim admitted to having the handgun in his fanny pack to the officer.
So can you file those conditions on all these gentlemen? Or I guess, let's go through each of them. Do they have Texas driver license?
They all have eligible Texas driver's license.
Great. All right. One more thing, gentlemen. You are not allowed to drive unless you have liability insurance in your name. If you do not have car insurance, then you're not allowed to drive. If I find that you drive without car insurance or you violate any of these conditions, I will put you in jail. I will do everything in my power to protect my community. Imagine you hit something at 125 miles an hour. You crush anything. Do you understand? I will have you each take a seat while we craft your bond conditions. We'll have you sign it. Because you guys have lawyers, I will waive your appearances. So you don't have to waste your time coming to court, but you must stay in touch with counsel and they will tell you when you have to come back to court. If they tell me they cannot get a hold of you because you're ducking and dodging and playing games, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for your arrest. You become a danger to my community, I will issue a warrant for your arrest. Understand?
Yes, sir.
All right. I'm going to have you each go to Victoria, sign a reset, and then we'll have you take a seat in the jury box.
Gomez.
And then if you can file all those and all of them. Thanks, Brent. Texas or liability insurance, no racing, reckless driving, donuts,
Okay.
street takeovers,
Go ahead
and the like.
signature bonds behind you. Judge, they're all state's bond conditions?
I'll pass it.
Judge, are you ready for the next one?
No, I need, it's going to take her a little bit to get the conditions ready.
Rios?
Oh.
Oh, sorry. Rios, go ahead and sign.
Right.
I have reached the jury box. You're coming at time on the jury box.
And John signature. The jury's ready to sit.
Those earlier. It should be. Just keep it that way.
No, I was just working on those.
Sorry, I don't.
What's up, man? Where you been? How's that going?
Traveling a lot. Not like Monday, regular. I like how Victoria, it's gonna annoy you. Yeah, I think.
Marino?
And that's it.
Will,
No, they have some food.
William, you want to help me out? You ready?
Ready.
Come on.
All right, page 4, Dickerson, come on up.
We're doing Dickerson.
Got it.
You, Miss Taylor Dickerson?
Yes, sir.
Mr. Dickerson, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay?
Your Honor, on February 1st, 2025, the officer was dispatched. He met with an on-scene officer who stated he observed a vehicle traveling 70 to 65, 70 into 65. He failed to signal a lane change, nearly causing a collision with another vehicle. A traffic stop was initiated. Smell of marijuana emitted from the vehicle. Probable cause search conducted, and 3 pill bottles were located with marijuana inside 23.2 grams. Xanax also contained in bottles, which were not the correct prescription on the bottle, 3.7 grams.
Okay. Mr. Dickerson, I'm going to find that there's probable cause to go forward with your case. Does he have a valid Texas driver license? You mind running it? You're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you
Right.
understand? If you have both, then you may continue to drive. If you don't. And that's a condition of your bond. Do you understand?
Yes, sir.
I'm not putting any other conditions. Just be careful.
Yes, sir.
I believe he does, Judge.
Okay. So you have a lawyer. Because you have a lawyer, I'm going to waive your appearance, but just stay in touch with counsel and he'll tell you when you have to come back to court. Okay. So we're license good?
Yes, Judge.
Okay. So no conditions. We'll just send you on your way. Be careful. Don't pick up any new cases.
Yes, sir.
Just be good. All right. Okay, guys, please.
Thank you, sir. Donna.
All right, Judge, next is page 1. Butcher, come on up, right this way.
This way, this way.
Counsel, I didn't write the name for us. Did you send it?
Yes, ma'am.
That's okay. This is Elizabeth Butcher. Good morning, Miss Butcher. Ma'am, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Judge, on February 1st, 2025, law enforcement officer observed defendant's motor vehicle traveling 101 miles per hour in a 65 mile per hour zone. Pacing the motor vehicle speedometer at
Thank you.
9200 block West St. Houston in Harris County, Texas. Defendant's motor vehicle was observed passing multiple motor vehicles at the speed, passing through multiple lanes with moderate traffic. A traffic stop was conducted and be immediately detained. The defendant was ID'd with a Texas driver's license.
Ma'am, I'm going to find that there's probable cause to go forward with the case. Have you run her license, see if she has one? Do you mind? Please. I'm ordering you as a condition of your bond not to drive in this manner again. If I find that you do, I will take your privilege to drive away and I'm going to put you in jail. Do you understand? I'm making it a bond condition that you're not to drive recklessly, racing, street takeovers, donuts, anything of this matter. You become a danger to my city. I only have one place for you. Do you understand, ma'am?
Yes, Your Honor, she has a license.
Give me 1 second, Yashi. Do you mind filing those conditions? No reckless driving, racing, etc. Do you have a lawyer today, ma'am?
My first time, so I wasn't actually sure how the process worked. I was hoping,
I don't want to, let's not talk about the case. I've got a bunch of DAs here. The only thing I need to know is, do you have the ability to hire a lawyer or would you like a court-appointed lawyer?
I would like an appointed one until I can hire one.
It's up to you. We can give you a lawyer today if you want. You're always welcome to go hire one as well. I need you to fill out an application for me to see whether you qualify. So we'll give you an application. I'll have you sign a receipt, Victoria, and then I'm gonna have you take a seat in the jury box while we get your bond conditions. Do not leave until you sign our bond conditions though. All right? Okay, please. Hey, are you coming here today? You can zoom in. You can zoom in. Well, that's why I have Zoom. Okay, you tell me, Yasha, it's up to you, however you want, okay? All right. Okay, bye.
Go ahead and sign. Judge, for this one, I was on the phone, CHA or?
No, we'll give her an application.
All right, thank you.
She needs to sign conditions though, so we'll.
All right.
Just make sure you take it out so I don't sign it again, huh? This one right here? Oh, I see.
Yes, for Castellanos?
Yeah. Okay. Okay.
All right, Judge, next is page 2, Castillo, Edgar, come on up.
Do you have an arraignment? Do you have an arraignment? Do you have an arraignment?
I believe so. Yes.
Whenever you're ready, just let us know.
Will do it.
Edgar Castillo, come on up.
Yes, sir.
Mr. Castillo, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 31st, 2025, an officer was working an extra job at Home Depot and was alerted by the loss prevention officer that the defendant had entered the store, putting multiple power tools in a basket and exited the store with unpaid merchandise inside the basket. The officer was sitting in a motor vehicle and observed the defendant exit the store beyond all points of sale and head north in the parking lot. The defendant entered apartments across the street. The officer observed the defendant pushing baskets and approached the defendant. The defendant attempted to flee. The officer deployed a taser and placed the defendant in custody. The total value of items stolen was $519.98.
Got it. All right, Mr. Castillo, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to go back to any Home Depot. Do you understand? If I find that you do, I'm going to revoke your bond, put you in jail. No more PR bonds for you. Do you mind filing that, please? Okay. Tell me, do you have the ability to hire a lawyer, sir?
Yes, sir.
You don't want to apply for a court appointed? I don't want to talk about the case. Do you want a court appointed lawyer?
I mean, I could get one, but if I hire a lawyer, then I don't need the lawyer you're gonna give me.
Sorry?
I'm gonna go ahead and get a lawyer for myself.
You don't want a court appointed lawyer?
No, sir.
Okay. If you have a problem and you're not able to, just come back, let us know, and then we can appoint your lawyer. I'm going to have you sign a receipt of Victoria. I'll have you take a seat in the jury box. Let me get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Thank you, sir.
Don't pick up any new cases. Behave yourself.
Yes, sir.
You understand?
Yes, sir.
Okay, man, come on.
Judge, counsel's approaching for page 7, Gutierrez. come on
Anderson,
up.
How you doing, Doug?
happy Friday, man.
And you?
How are you?
Doing well yourself?
There you go. So who is it?
Pablo Gutierrez.
Gutierrez. Okay,
Page 7.
thanks. Man, a ton of reckless, what's going on?
Go ahead and sign for your.
All right, you are Pablo Gutierrez.
Sure.
Mr. Gutierrez, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Sure.
On January 31st, 2025, an officer observed a vehicle that came to a stop in the left turn lane at a stoplight which was red. I'm sorry, Judge, I'm reading from the DENS. This case is, I'm sorry.
Very well.
No, it's not, Judge.
Gotta love it.
It should be automatic, no PC.
Okay, it says the officer observed a Dodge Challenger run the red light in an attempt to make a U-turn in a sudden acceleration and almost strike a vehicle that was traveling north and had a green light. The vehicle had to perform an emergency maneuver to avoid the Dodge, but did not stop and continued northbound on Westlake Houston Parkway. The officer initiated a traffic stop. And the defendant was pulled over for reckless driving and running the red light.
So you said he's at a stoplight?
Yeah, so he ran the red light in an attempt to make a U-turn while somebody else had a green light and almost struck the other vehicle. And he
Okay.
also had 0.20 grams of Tylenol on him. That's what the DIN says.
So I'm gonna find probable cause now. Do your diligence, get the video. If you show something different, come back, let me know. We can always revisit probable cause at a later time, okay? Do you see whether he has a Texas driver license, please? Okay. Mr. Gutierrez, I'm gonna find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to drive in a reckless manner, no racing, street takeovers, donuts, anything of this manner. If I find that you do, that you put my public in danger, I'm gonna revoke your bond, put you in jail. So you understand?
Yes, sir, I do.
Eligible driver.
Okay. Now he's on felony probation upstairs. Are you familiar with this?
Not with the felony probation judge. Does it show they filed
He's,
MAJ yet?
I don't know. Let's look. You're on probation. It looks like it may be a second or first degree felon. Yeah, second degree felon. So just be on the lookout, it's very well, they may file a felony warrant now. He's already had one MAJ dismissal, so be on the lookout, sir.
Yes, sir.
So do you mind filing those conditions, please? All right, you're also, Mr. Gutierrez, not allowed to drive unless you have valid liability insurance in your name. If I find that you drive and you don't have car insurance, likewise, you'll end up going to jail. You understand? Now you have a lawyer. Because you have a lawyer, I'm going to waive your appearance, but it is your responsibility to stay in touch with Mr. Henderson, and he'll tell you when you have to come back to court.
Sure.
If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for arrest. For now, I'll have you sign a wreath of Victoria. We'll have you take a sit in jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thanks, guys.
Now, just you?
Got it.
All right. He's in the jail.
No, yeah.
All right, Beth, next is page 7. Hayes, come on up. Hayes, Misha. All right, go ahead and have your details. Maisha Hayes.
All right, good morning, Ms. Hayes. Ma'am, you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On February 2nd, 2025, an officer was dispatched to bombshells in Harris County, Texas. The officer met with the complainant, and the complainant stated she tried to leave the establishment following an argument with the defendant and her girlfriend. The defendant grabbed her by the arm. A struggle ensued and was broken up by 2 off-duty officers working at the establishment. The off-duty officer stated they saw the defendant grab the complainant and they moved quickly to break up the altercation. Based upon the information, the officers attempted to arrest the defendant for assault, family violence, physical conduct. While being searched, incidents to arrest, the defendant began pulling away from the officers and kicking to prevent being arrested. The defendant refused to enter the patrol car by standing on the step by the bar and yelling.
Did they file the assault or no? Did they file the assault or no?
They did not file. No, they did not file the assault, Judge.
Okay. Ms. Hayes, I'm going to find that there's probable cause to go forward with your case. They didn't file it. I mean, I'm not going to put any conditions on her case then, I'm not putting any conditions on your bond. Just be careful. Don't pick up any new cases. Be good while you're out there. If you pick up a new case, start misbehaving, I'm going to put your bond. Would you like to apply for a court-appointed lawyer, ma'am?
Yes, do y'all have that?
So Deputy Miranda's going to give you an application for an appointed lawyer. I don't want to talk about the case, but you can tell the lawyer and the lawyer can, talk with us if need be. Okay?
Carlos Gomez.
Please, ma'am.
All right, go ahead and sign for your receipt, please.
Reggie, who do you have?
Good morning, Judge. I have, Your Honor, I have, give me a second here.
Page
Uh,
page one.
I have 25.
I got it. Conseco.
Yes, sir. Yes, Your Honor.
Do you need a translator?
I don't think so, Judge.
Conseco. You need a translator? Okay, just take a seat for me. We'll find you one.
Okay, thank you, Judge.
Just bear with me. When we get one, I'll let you know.
Thank you, Your Honor.
All right, Judge, next is page 11. Learner, come on up.
Are you Miss Smly Lerner?
Yes.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 30th, 2025, officer ran a check on a vehicle in Harris County, Texas, without proof of financial responsibility. Vehicle also had a defective brake lamp. The traffic stop was initiated. Defendant driver ID'd by Texas driver's license stated she did not have insurance for the vehicle. Officer observed defendant to have thick
Bloodshot eyes or thick slurred speech.
Speech and the odor of marijuana emitting from inside the vehicle.
Officer asked defendant when she last smoked inside the vehicle. Defendant stated she had a few roaches inside the vehicle. Probable cause search was conducted. Officer found 0.103 ounces of marijuana. A DRE officer arrived on scene and conducted Romberg test. Defendant estimated passing of 30 seconds and 12 seconds. Shows D is in an elevated state. DRE also observed thick SS, FSTS conducted, 6.6 HGN, 3 out of 8 on walk and turn, 2 out of 4 on one-legged stand. When defendant was arrested, D repeated the phrase, "Oh my God," several hundred times. Officer knows from ARIDE training that this is a symptom of dissociative anesthetic. The SC read, D refused to sample the breath, blood. Search warrant signed and executed.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Can you look to see if she has any prior DWIs? Number one. Number two, if she has a valid Texas driver license, please.
No prior DWIs.
Okay.
And your driver's license.
Great, okay. Ms. Lerner, like I said, no alcohol, no drugs. I'm going to randomly test you. Do you have the ability to hire a lawyer or would you like a court-appointed lawyer? Okay, I need you to fill out an application for me. I'll take a look at it. And then for now, I'll also have you sign a receipt with Victoria. I'll later have you get with Fleischer for your bond conditions and then I'll have you meet with a lawyer. in a bit.
License being suspended.
I'll let you talk to a lawyer about it. I can't give you legal advice. No, assuming we give you a lawyer, you can ask the lawyer and the lawyer can advise you properly.
I need to start working. I lost my job.
Just, yeah, talk to the lawyer and they'll be able to advise you properly. I haven't, as long as you have a valid Texas driver license and you have liability insurance, I'm not taking away your privilege to drive. Okay? So, yeah. All right, let me have you get with everybody and then we'll have you speak to someone here momentarily, okay? Please.
Go ahead and sign. Next, Judge, is page 13. Neil, come on up.
Are you Mr. Juan Neal? Mr. Neal, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 31st, 2025, officer observed a vehicle with an expired registration. Traffic stop was initiated. Upon contact, officer approached rear side passenger vehicle and asked defendant to roll the windows down due to the tint. Officer then approached passenger side and observed HOMJ emitting from the vehicle. A PC search conducted, officer found a black bag containing a jar of marijuana inside on the passenger floorboard. Officer found a firearm under the front passenger seat.
So he's the passenger then, right? Or is he the driver?
Driver's on. Let me double check.
Is he a driver? Was he?
We're not gonna argue PC on this case if you want to find him PC. He was not the driver, he was the rear passenger seat. There's nothing in the DINs that really connects him to the gun.
Okay, all right, Mr. Neal. Careful who you hang out with, you know? You hang out with dogs, you get fleas. Just really, you got one life. Live it to the best you can, all right? I'm gonna find no probable cause, just be careful, all right? Okay, just hang tight for me.
All right, Judge, next is page.
Thank you, Mackenzie. That's great.
15.
That was Neil.
Next is page 15, Reyes, come on up.
I love our prosecutors. Vic, who's this?
Reyes on page 15.
Got it. You are Adam Reyes. Mr. Reyes, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 23rd, 2025, law enforcement officer observed a black Silverado and a white Honda Accord at the 7800 block of State Highway 6 turning left at a high rate of speed. The law enforcement officer made a U-turn at an intersection that followed both motor vehicles, having to travel approximately 66 miles an hour in 40-mile-an-hour zone. The officer observed motor vehicles to be side by side with the Honda flashing emergency lights. The law enforcement officer observed Honda turn off the lights. Both motor vehicles began to speed up again while driving side by side, and they ran a red light. The officer attempted to catch up with both motor vehicles, causing the officer to travel approximately 90 miles an hour in 40-mile-per-hour zone. The officer briefly lost sight and re-observed the Silverado as the motor vehicle continued traveling eastbound. Traffic stop was initiated. The officer made contact with defendant, driver, the sole occupant. The defendant stated when asked about high rate of speed, "No, I was on my way home with my friend Adam, and Adam was following me home." Co-defendant arrived claiming he was there to check on the welfare of defendant. The co-defendant stated, "I was following him home, but I broke off because I wanted to get something to eat." Defendant ID'd with a Texas driver's license.
And Mr. Reyes, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to participate in this type of activity again. If I find that you do, I'm going to put you in jail and then I'm going to take your ability to drive away. Do you understand? Can you look to see if he has a valid Texas driver license, please?
Yes, Judge, eligible.
Do you have the ability to hire a lawyer, Mr. Reyes, or did you want to apply for an appointed lawyer?
I'll hire one.
Okay, I'm going to have you sign a receipt, Victoria. I'll have you take a seat in the jury box while we get your bond conditions, while you sign it, and after that, you'll be free to go. Be safe in my city. Do you understand? All right.
This way. Next judge is page 16, Romero. Take a seat in the jury box. Translate. Romero. Okay. You can have a seat.
You need a translator? Okay. Oh.
Thanks. Page 18, Thornton, come on up.
You are Ricky Thornton. Mr. Thornton, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, the complaining witness and the defendant are in a dating relationship. And on December 18th, 2024, in Harris County, Texas, officers were dispatched to an assault call at a hospital. The officer arrived and made contact with the complaining witness, who stated that she and the defendant are in a dating relationship. The complaining witness stated that earlier in the day, she and the defendant were in an argument due to the complaining witness telling the defendant that he needed to leave the location. When the complaining witness got up to leave, the defendant pushed her through a wall, causing her to crash through the wall, causing pain. The officer observed the complaining witness to have a laceration over her right eyelid, swelling and bruising.
What's the problem in this case? Something went wrong. Something's wrong. I'm showing that the case is dismissed when it shouldn't be.
This is Thornton, Judge.
Yeah.
My suggestion yesterday.
Or is it? I don't know. I don't even,
It is a DVD case,
Or
Judge.
Mr. Witness.
I don't even see a knowing.
For Thornton, it's not published, Judge.
Judge.
I mean, ready to publish.
Judge, you said he spoke with Chief Campbell Smith for missing witness due to.
So it is dismissed then, right? Okay, your case has been dismissed, believe it or not. Just be careful out there, you know? Just, today's your lucky day. Count it, all right? Okay, man, good luck. That's okay. I did too. I don't even see a copy of the dismissal here. That's why I was kind of threw me for a loop, but Gabe knows, you know?
All right, Judge, next is page 10.
Okay.
Leonard, come on up.
Matthew Leonard.
Yes, sir.
So Leonard, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Judge, on 4/12/2023, officers were dispatched.
Hey, yo, hey.
Another story about that right here. On 4/12/2023, officers were dispatched to a crash involving a bus and a car at the 1700 block of Travis Street. Officers made contact with the defendant, who was slumped over in the driver's seat of the car. Officers observed the defendant to have red and glassy eyes, strong odor of alcohol in the breath, SS, and slurred speech and incoherent speech. The defendant told officers that he was drinking 211's beer at his house and last drank 2 hours ago. The defendant was taken to the hospital and diagnosed with a minor brain injury. Officers got a blood warrant. There was a blood draw completed at JPC.
Then, so what, do you have the results? Hold on a second, let me see.
No, not yet.
No, Judge, we don't have any blood results
I see
yet.
it.
For some reason, there haven't been any to-dos done on the case. I'll submit them immediately. That's.
Well, it looks like it's because it was a 2B, that's why. So it's from April of 2023. Looks like there was a blood of a point. Yeah, 0.198. Okay, Mr. Leonard, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. Because it's a second offense, I'm now ordering you as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. Miss, can you run his license, see if he has a valid Texas driver license, please? Do you have the ability to hire a lawyer, sir?
How much time can I pass this? Because I'm in the process of getting my ID and everything, because when I got locked up, I didn't have my wallet. They threw it away or something.
Would you like a lawyer, sir? I can give you a lawyer today. Okay, so understand something, Mr. Leonard. I don't want you drinking. I don't want you using illegal drugs. I'm gonna randomly test you, and you're gonna have, do you show a Texas driver license?
It's all good.
Okay. All right, sir. So what I'm gonna have you do now is I'm gonna have you sign a bunch of paperwork with Victoria, Felicia, and then I'll have you meet with the lawyer here momentarily. Okay,
Yes, sir.
please.
Right this way. All right, Judge, counsel is, go ahead and sign for your rescind. Sebastian, are you approaching?
Yeah, I'm approaching with,
Oh,
Sit down, you ready? Come on.
Judge, they're approaching for page 17, column 17.
Okay.
Judge, you want to bring up the client?
Please. Driver, come up. So Mr. Shriber is on bond for a harassment case. He's now picked up a new case.
Yes, sir.
You now stand charged with the offense of assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 31st, 2025 in Harris County, Texas, officers responded to a family disturbance call. Upon arrival, officer met with the complaining witness, who stated that she and the defendant are married. Complaining witness stated that the defendant had arrived home drunk and that she hid alcohol from him, leading to an argument. The complaining witness stated that the defendant then grabbed her by her hair and pulled, causing pain.
Is this the same complaining witness in the harassment case?
No, Judge, this is going to be the defendant's wife. I've since spoken to her today in the back in the witness room.
Who is the
So
complaining
my
witness in the
understanding is
harassment?
that in the harassment, it's a neighbor, and then we now have the wife as the complainant.
Judge, if I may, then you may remember the old case. It involved a family that lived about 8/10 of a mile away and involved a dirt
I
bike.
don't remember anything.
And as a practical matter, no, it isn't a neighbor. It's a person who lives in the area. They don't, live next to each other. After this incident happened with the harassment case and his wife is here in court, Mr. Shriver's now enrolled to go to a facility called Mallard Lake. It's a rehabilitation facility that addresses alcohol problems. He's going to be enrolling on Sunday. And they've sent the enrollment paperwork to my office yesterday. We are hoping that we can reset these cases to allow him to attend that. That is an inpatient program. We don't know how long he will be there, but I would anticipate it's going to be not less than 14 days. But of course, it's one of those things they'll judge his success as he goes.
I am all for it. But you picked up a new case while you're on bond. I'm not going to let you go. I'm not going to give you any preferential treatment. You have to abide by all the rules, regulations as well. And when you pick up a new case, there are consequences. You're old enough to know that. When you have actions, you take the wrong action. There are no mistakes in life. There are actions. And when you take the wrong actions, there's serious consequences. I'm now revoking your bond on the harassment case. You're staying with me. Now, hold on. I'm not done with you. I'm also ordering you now not to consume alcohol, illegal drugs, and I'm going to put a monitor on your ankle so I know that you're not consuming.
So I still want to go to rehab?
Then we'll talk about that.
We'll work through all the, all the issues as far as there, but I'm not going to take your word for it that you're not going to consume. I need more concrete evidence. And the way that I do that are with these devices, and you're now with me, absolutely no tolerance. If I find that you're now a further danger to my community, I'm going to go nuts on your bond. Do you understand? So what does wife want? Does she want to continue to have contact with him?
She is here to ask that the court modify the conditions of the magistrate order for emergency protection. Since this incident happened, Mr. Shriver's been living in a hotel. They've abided strictly, even with their communication and transportation today, with the no contact. However, she is asking that we remove that restriction and instead go with the no threatening or harassing communication.
I've spoken with her and confirmed all of council's represented, and we're not going to be unopposed. We're not going to be opposed to modifying it to no threatening or harassing.
So you have an order for protection that's been put in place by the magistrate. I'm leaving everything in that order intact except for one thing. Well, I guess two. Does the MOA also say no contact as well?
It says no contact and don't go to their.
Got it. Okay, so I'm going to modify two things. The first thing I'm going to do is I will take off the residential restriction. Number two, I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case. You need to understand what is threatening or harassing doesn't matter what you think. I could give a rat's behind what you think. It's what she perceives. So if I go like this, is that threatening or harassing? It most certainly is, and it can land you in custody. And I'm going to tell you now, any more issues?
That's why I'm going to rehab, sir. Yes, sir. I understand.
You know, there are people in life when they drink, they're very happy, they're the life of the party.
That way.
Yeah, and then there are people who develop horns when they start drinking. If this is you, there's one easy solution. So what we'll do is I'll put the monitor on him. I'll waive the fee. Okay. I guess, correct. No alcohol, no drugs, random testing, no weapons, no threatening or harassing contact with the complaining witness, the scram monitor, waive the fees. Get with me as far as the facility and what they say about him having the device on, and if they're okay with it, if they're not okay with it. If they're not, then we can work something out. But the minute he gets out, the next day, he's got to get the monitor on if they have a problem with it. And then you must charge this device every single day. If the battery goes dead, so does your bond. Do you understand? All right, so I'll set the new bond at 5,001 on the harassment case, and then we're done. All right, goes with you. Okay, Mr. Downey, so just
We'll get a reset, maybe 45 days out, should give us enough time.
do that. I need proof though. Like, get me proof that he's actually enrolled and how long he's going to be there. On the harassment case, he's going to make bond. They'll give you a 7-day setting on that afterwards. Feel free to get with Victoria so that way you can match up the date after you get the new date, and then
I have the paperwork. How do you want me to get that to the court on the?
if you want to email it to us, it's okay. Email. It's
Okay,
probably the easiest. That way you don't have to come in and waste time.
no problem. Yeah, I will get it to you right now.
And then just one more thing, always just CC Sebastian. That way they always have it as well.
Okay. No problem.
Okay, all right, guys.
That was 5,000 over there.
Correct.
Thank you so much.
Will, was that, do we have any more arraignments?
So we're waiting on the interpreter.
Got it.
That's it.
Will, ready?
Good,
Hey,
sir.
You'll-
Mr. Johnson, Daryl Johnson.
Daryl Johnson, come up.
Judge, I did go ahead and send Mr. Johnson for a talk test
Okay,
this morning, and I came back productively for THC.
Oh, that's definitely, that's, yeah. Okay.
If I can get some context, Stronger, when you're ready.
Got it.
So Mr. Galden has been on, I'm sorry, Mr. Galden, Mr. Johnson's been on signed bond conditions saying random UAs. He was asked to give a drug test, but it went to a different number. He didn't receive a notification to get drug tested. He went today, got tested. They had the right information. I've talked to the state. We've discussed the case. They've made a PTI offer for anger management AAs, which we have accepted. I don't know what the court wants to do today, but I want to give you a whole picture of the case that we're close to resolving it. And there was some communication issue.
do whichever you guys need to do, right? But you're not allowed to use. And I'm going to test you 45 to 50 days from today. And if you test positive again, I'm going to keep you. Do you understand, Mr. Johnson? I'm not going to play this game. You're not allowed to use. You will get tested again, it's positive again, it's not going to go well for you. All right, take a seat.
Thank you, Judge. Have a seat.
Well.
Judge, we have the interpreter.
Wonderful.
Bottom of page 1.
Okay. Reggie, you ready? Manuel Canseco.
Morning, Judge.
25.
Canseco.
No sé si interpreté.
Okay, gracias.
Por favor, contesta.
Mr. Canseco,
Señor Canseco.
just so you know that you're not here alone, your lawyer is here with you, but on Zoom.
Okay.
You were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 30th,
30 de
2025,
enero del
at
2025,
2:07 a.m. in Harris County, Texas, an officer observed a vehicle with expired registration as of November 2024. A traffic stop was initiated. The officer made contact with the defendant and observed red, glossy eyes, slurred speech, and the odor of alcohol emitting from the defendant's breath. The officer detained the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HDN. 7 out of 8 clues observed on the walk and turn, and the defendant refused the one-leg stand. The officer observed 2 small baggies of a white powdery substance in the defendant's pocket, known by the officer from training and experience to be cocaine, 0.22 grams, which is a usable amount. The DIC was read, and the defendant consented to a breath test. The results were 0.173 and 0.169. The defendant stated he drank 7 beers and 2 shots.
You need priority to be honest, number one.
No criminal history, Judge.
Number two, you see if he has a valid Texas driver license, please. Mr. Canseco, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you have a problem with drugs or alcohol, you better address it, because if you don't, I'm going to do it for you. And I promise you, you're not going to like the way that I do it.
Eligible driver's license.
You have a lawyer. It is your responsibility to stay in touch with Reggie. If he tells me he can't get a hold of you, you become a problem while on bond, then I'm going to put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they can possibly put a detainer on you and you will be stuck in custody until this case is over with. Do you understand?
Yes.
Okay. I will have you sign a receipt, Victoria. After that, you'll get with Felicia for your bond conditions, and after that, you'll be free to go.
Okay,
Reggie, do you want the same day as the felony?
Judge, can I have the day afterwards, please?
Are you representing him upstairs?
Yes, sir.
Okay.
Monday, the 17th?
Let me see.
What, just the day before, day after, Judge, would be good.
Yeah, but we don't do Fridays because it's an arraignment day. So how about that Monday after? Is that okay?
Sounds great, Your Honor.
Okay, it's yours.
Have a great day, Judge.
You too, man. Take care.
Thank you, Your Honor.
Judge is page 16. Romero, come on up.
Por favor, conteste en una voz alta.
Okay.
Gutierrez, Pablo.
Are you, Mr. Romero Moran?
Ay, Romero.
Romero Moran?
Yes.
Sir, you were charged with assault of a family member. You are
Yeah.
facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 29, 2025, in Harris County, Texas, officers were dispatched to a family disturbance. On arrival, the officer spoke with the complainant, who is the defendant's daughter. The complainant stated the defendant had taken her vehicle. When the defendant arrived, the complainant asked about her keys. The complainant stated the defendant was intoxicated and started to yell at her. The defendant then approached the complainant and aggressively grabbed her legs, pulling her off the bed, causing the complainant to hit the floor, causing pain. The officer spoke with the complainant's mother, who confirmed that the defendant had grabbed the complainant and pulled her off the bed. Another witness also confirmed that.
Do we know whether she wants to have contact with him?
I spoke with the domestic violence prosecutor today, and we are requesting no contact, Judge. And also, it's alleged that the defendant was intoxicated, as I said before.
I get it. So, Mr. Romero Moran, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. Do you understand?
Yes.
If I find that you do, I'm going to put you in jail. No more PR bonds. I'm also ordering you as a condition of your bond not to have any contact with the complaining witness in this case.
Okay.
I am entering in what's called a magistrate's order for emergency protection. This is an order that identifies Ms. Romero as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot stalk, threaten, harass, communicate with her in any manner.
Okay.
You cannot be in possession of a weapon or go within 200 feet of the Winter Glen Lane house.
Yes.
Do you understand?
Yes.
Yes.
If you violate this, the state can and probably will file additional charges against you. Violation of a protective order, and that is one of the worst cases that you can pick up.
Okay.
Okay.
Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer, sir?
Yo lo puedo pagar, no tenía dinero, por eso no vino conmigo.
I could pay for one. I didn't have any money. That's why he didn't come with me.
I'm happy to give you a lawyer today if you would like.
Nombrarle un abogado, si usted quisiera.
Sí.
Yes.
Understand?
Entiende.
Don't violate these conditions. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you because they sweep it every single day, they will put a detainer on you and you will be stuck like Chuck in this thing until the case is over, and then you get shipped off to immigration. You will not get any more warnings.
Advertencia.
Okay.
All right. So for now, I'll have you sign a receipt. Victoria, do you mind giving me an application, please? I need you to fill out an application for me for an appointed lawyer, and then I'll have you meet with Fleischer here in a little bit for your bond conditions.
Se reúne con él para las condiciones de fianza.
Right, Judge, we have one more on page 12. Moya, come on up. Romero. Moya, yes, right up there.
Good morning, Ms. Moya. Oh. Do you speak English or do you need?
I speak only English. Yes, only English.
You speak English?
Yeah, only, yes.
And you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 29th, 2025, an officer was dispatched to a Valero parking lot for a suspicious motor vehicle that may have been stolen. Loss prevention on the motor vehicle came back to the license plate, sorry, on the motor vehicle came back to a white Ford F-150. The vehicle identification number on the vehicle was different than what had returned. The defendant got out of the suspected motor vehicle and the officer was performing a felony stop on the possible stolen vehicle with multiple items in her hand. And the defendant refused to obey commands when told to drop them. The officer stated that he told the defendant to face away from him and walk backwards with his hands up, with her hands up. The defendant refused to obey commands and walked towards the officer with her hands down and facing him. The defendant kept moving back towards the front of, the defendant kept moving hands back towards the front of her body while the officer attempted to put on handcuffs on the defendant. The officer ordered the defendant to walk towards the patrol vehicle, to which the defendant refused and had to be escorted by force. The defendant kept moving her hands away from the officer and he attempted to handcuff her again. The officer had to take the defendant to the ground due to the defendant attempting to free herself. The defendant continued to move around so she could not be handcuffed.
She the driver or the passenger? Is there a co-defendant? Did someone else get the UUMV?
It does not appear there's any co-defendant.
It's a passenger.
Stop. Ma'am, don't.
All it says is that she got out of the suspect vehicle.
Ma'am, I'm going to find that there's probable cause to go forward with the case. If you do not have a Texas driver license, you are not allowed to drive. Do you understand me, ma'am?
Yes, sir.
Also, you need liability insurance if you're going to drive. If you don't have either, then you're not allowed to drive. Do you understand? Do you have the ability to hire a lawyer or would you like a court-appointed lawyer, ma'am?
Court-appointed lawyer.
Okay, I need you to, let me see if I have an application. I need you to fill out an application for me. I'll take a look at it and then we can appoint you someone later today. Do not leave until you sign our bond conditions though, ma'am.
Yes, sir.
All right? Okay, please.
That's it, Judge.
Got it.
It's just
And I'll follow
What
the-
is that?
Thank you, ma'am. Are you ready? Do you have an arraignment?
Yeah, no, I don't have an arraignment, Your Honor. I have extradition, Mr. Hunter.
I don't have the prosecutors here. Let me see, let me reach out to them. Oh, she's here. Sorry. Okay, I didn't see her. Amy,
Sorry, yes.
so you have Hunter, you said, right?
Yes, Kenneth Hunter.
Okay.
And I believe I'm gonna make an appearance on the original extradition, which was out of Knox County, Tennessee. I think that you were in here maybe a week ago.
Can I bring him out real quick so he hears everything?
He is, Your Honor, he is.
They got Hunter coming out?
Yeah, this was originally Shibley's case. I coached Nicole on this one.
I don't remember anything. It's just, we go through so many, it's hard for me to remember. It's just, when he comes out, I guess refresh my memory and let us know. So all I know is that we have now a new fugitive case, right?
Yes. So now he'll have a total of 3 people on him.
Know this beforehand that this was gonna pop up?
Yes.
And you're representing him upstairs on the felony theft?
On the local one, yes, yes, Your Honor.
Lori, you want to talk to me while we're waiting? Okay, who?
Paris Wilson. She's charged with failed to ID. She's on here on an MRP for an ag assault. Her bond is
Alright.
$100. She can't afford it. She has a newborn and a 2-year-old.
Has she made bond? Is she on bond or did she need to make bond on it?
She is not on bond on it. They gave her $100 bond because she.
No, but on the felony case.
In the felony, she needs to go there to see if they can give her one, to see if she can make one.
Let me read this to you real quick. This is the magistrate. Defendant held at zero bond for MAJ on ag assault with deadly weapon. This case, traffic stop failure to signal lane change. Defendant driver gave name Chastity Petrie and false date of birth. Defendant eventually gave correct name, admitted she knew she had a warrant. Let me talk to her.
Okay.
And then I will.
All right, I'll look it up.
All right.
Prosecco?
All right. Good morning, Mr. Hunter. We're bringing you back because you now have a new fugitive case and you have a new lawyer. What would you like?
No, we're seeking fugitive bonds on these matters. The new matter, to the best of my knowledge, this from North Carolina, is basically the same complainants of the Houston case. Same folks. I think their surname is Beaker. I think a $30,000 bond has been set in the case here in Harris County. We would respectfully request bonds in the amount of $20,000 on the 3 fugitive warrants. And let my client sort things out with those other jurisdictions as well as ours.
Your Honor, because of the fact that he has now 3 fugitive cases in our court, 2 out of Knox County, Tennessee, and now a new one out of North Carolina County, we'll be asking for no bond.
I told him beforehand, we've visited this issue before, and I told him the last time that he was here that I wasn't going to give him one. He just got way too much baggage. And it's all the same thing where it's a theft from an elderly, and we have the same thing that's occurring over and over and over. You know, and it scares me that if we let him out, is he going to pick up a 5th case, you know? Or it just, it's so much baggage. He scares me, you know? And
He does have, he's kind of been a resident of this area, you know, for 25 years. So
I get it, but he's got a lot. He's hopscotching with the states as far as criminality, right? He's got 2 cases in North Carolina, or 2 in Tennessee, 1 in North Carolina. Now he has 1 here. He's got, in 3 different states, he's got charges. It's too much. And I think that because of that, he's a big flight risk, and I don't want to lose him. You know, and he knows this because I've told him this before. You're not the first person that has approached on me with this. You know? So yeah, it's just, you got to understand that there's a lot that comes with this, right? If it was 1, perhaps, right? But you've got 3 in 3 different states. It's way too much. You know, at some point, it's got to stop. Now's that time. So the idea is that has he made bond? He hasn't made bond on the cases upstairs, right? So because you have not made bond, the 14 days here that would normally kick in is told if and until that hold upstairs is released. So if you're able to make bond on that theft case upstairs, that would kick in the 14 days for those states to come get you. And then they would have to battle it out as to who comes and whatnot, and, you know? So I guess just let me know what you guys want to do. The felony court is set for March 11th. Typically what we do is we just set it the day after. And I'm sorry, Mr. You know, but it's just too much. Yeah.
Your Honor, I do also want to add, he hasn't waived on this new North Carolina case, so he wants to start that clock today.
And I'll let you guys see if that's something that you want to do. You know, if not, we can go ahead and get a governor's warrant. That'll take 90 days. But, you know, if you post bond on the case upstairs, that would get the ball rolling really, really quick. So, okay. You guys let me know what you'd like to do. Thanks. Hi. Hey, happy Friday, man.
Happy Friday. We are here.
Who do we have here?
We have Herman Riley, Judge, Riley.
Morning, Mr. Riley.
Requesting a bond.
Okay, Mr. Riley, I've never met you before. I don't know you. I got to get to know you in the short time that we have here to see who are you? Are you a danger to our community? Well, everybody tells me that, right? Hold on. I know that you have a statement that you want to say, but what really matters is the paper, because that really tells me who you are. I get people that try to sell me the sun, moon, stars, everything here, but that really tells me who you are. So, Day, let's get to know Mr. Riley.
Your Honor, he's wanted out of Louisiana for domestic battery involving child endangerment and theft, but the theft is a misdemeanor, so he's only being extradited on the domestic. It was where he is alleged to have bitten his live-in girlfriend in front of a shared child and a second child, a 4-year-old and a 7-year-old. The warrant was issued on May of last year, so we're getting close to a year, Judge, for the.
So he's been on the lam, you're saying, for a year?
Well, I don't believe it's an FTA. I believe it's a 2B warrant.
It's a 2B? Okay.
I don't show any other history, and so state just requests that a sufficient bail be set, but I don't know of his ability to.
So you're okay with the bond?
I'm okay with a bond. I'm not okay with a low bond.
Judge, my client has requested that he address the court.
Yeah, I know.
So let's not talk about the case, because you have the right to remain silent. Anything you say can and will be used against you. You got to understand that I have a ton of prosecutors here. Whatever you say, they're going to sit there, type it down. It's very possible it may get back to the prosecutors in Louisiana somehow. So don't talk about the case.
Myself.
My only concern is, you know, if I set you a bond, number one, are you going to be a danger to our community? Number two, are you going to go back to Louisiana? Those are the main and primary concerns.
That's what I want to assure you of. Okay, right now I'm working, you know, if I stay here 14 days, I may lose my job. I pay on child support and everything. I talked to the bondsman in New Orleans already, you know what I'm saying? So as soon as I go up there, he gonna walk me out, you know what I'm saying? I'm gonna take care of the bonding and everything. But I just wanna let you.
It's set there?
I'm checking that right now, Judge. No, there's no bond set, which means they'll set one as he self-surrenders, but I don't know what they would set it at.
So typically the way it works is if we set you a bond, give you 14 days from the date of your release to go turn yourself into Louisiana. If you fail to go do that, you have to understand that there are serious consequences. I will revoke the bond, set it at 0, and I'm not going to give you another one. I don't care if you're kicking and screaming and Jesus told you to do something. I don't care. We give you one shot to go turn yourself into Louisiana. You understand?
Yes, sir.
Okay, so let's talk about a bond amount.
Your Honor, due to the offense and the fact that 2 minor children were present and the age of the warrant, is a state requests a bond of $7,500.
Judge, we'd request a bond set of 1,000.
Big difference.
It's pretty big divide, Judge.
So the problem is also is that because you're a fugitive, right? You are an inherent flight risk. So the normal 10% that one would have to pay to typically bond out usually does not apply in fugitive cases, as far as I've been told. So you will probably have to pony up 100% of the money to be able to bond out on a fugitive case. So I guess speak with him, let me know, you know, what's something that you guys.
He told me he could make $1,000 bond.
Yeah, I think 1,000 is too low. You know.
That's the amount that he can make.
That's too low. I mean, that's what we do on normal cases, not just, you know.
Unless I get new information, Your Honor, just again, due to the age of the warrant and the fact that there were minors present, is unless I get new information.
I don't want to keep you, right? But I have to make the bond sufficiently high so that I know that you're going to go back, right? What I'll do is I'll set your bond at $2,500. Okay? And then just let me know, what we can do is, has he already waived or no?
No, he has not.
Have
We
Abel
thought-
reach out to your folks, your family, to see that's something that, whether you guys can make it. And
Under 2,500.
this is not I'm not gonna negotiate with you, dude. It's just that 1,000 on a fugitive case with this type is just too low.
And also, just reminding the council and the court is that even presuming that he's able to make this because Louisiana has set at no bond for him to return and go back to work, he has to make a secondary bond there. And if this is the maximum he is able to pay, then effectively he'll be held in Louisiana and he won't be able to return.
I'll also have to take that into consideration.
Judge, my client has chosen to not take the bond until, if that's okay with court.
2,500, like,
Don't argue with it.
no, no, I'm not arguing. I just want.
Here, look, let's do this.
My job and everything.
Let's do this. Let's do this. I'll let you guys go back there, talk about what you can make. 1,000 is just too low, but I'm willing to work with you because, really. But you guys, no, let's not do it here. Go back there, talk,
I'll stand down, Judge.
Christine?
Thank you, Judge.
Thank you, Dane. Is she with you?
No, she's with him.
Oh, Lori. So this was Miss,
Wilson, Paris Wilson.
morning, Miss Wilson. You're on a deferred, the type of probation for an extremely serious case. I mean, it's about as serious as it comes. You're supposed to live with a halo over your head, Don't say anything. I'm just telling you, you gotta live like you got a halo over your head. You've picked up a new case with us. Lori is asking me to give you a PR bond, and I think everybody deserves a chance. So I will give you a PR bond now, but I'm not gonna play this game. If you continue to pick up new cases, if you're a danger to my community, I'm not gonna keep doing this. Do you understand? Okay. The problem is that you've not made bond upstairs, so I don't know if you're gonna be able to, whether they're gonna give you a PR bond or one, I don't know. So I will give you one with us on our failure to ID case here, but be good. It's not hard. Be good. No. Tell Lori, just what you gotta worry about is upstairs, not us. Just be good. It's not hard. Do you know when the felony
They
case is?
they haven't put a court date on there.
Actually, they have. 2/12.
Oh, okay,
Next
so
Wednesday.
Wednesday, and I'll reset you until the Tuesday after that.
You want to do the next day, perhaps?
Okay, we can do Thursday. All right.
Keeping the bond of what it set up?
Yeah.
I can't get rid of this.
Okay, you ready?
Judge, can you check the waiting room?
Is this guy a lawyer? Do you know?
What's his name?
Eduardo Garcia?
Yes, his office just called, but I can call and make them, have him verify. He
Please.
is. Okay.
Okay, so PR bond approved. Okay, hi.
Good morning,
Happy
Judge.
Friday.
Happy Friday. I have Ms. Destiny Collins on docket today. There was a bond violation report submitting on the 31st for failure to show up for drug testing.
I'm bringing her up.
But no, she's not here because she actually went into custody on her motion to revoke case on the 27th in Galveston County. So she was in custody at the time she was supposed to test. And I emailed the court just to verify that she actually was,
Do you know that 100% certainty that she's,
actually,
so what is she in custody for?
so she was on probation and then she picked up this case and they finally did the MRP on that case for this case.
What's she on probation for?
Theft,
That felony theft?
yes,
You know what the bond's set at now?
25K.
Is she gonna make it or no?
She's likely not going to make it. She goes to court on the 14th of March for her, for that case.
Can I go ahead and put the hold now, or what do you want to do? Because the problem, my fear is that we just reset it, right?
Yeah.
And then she just doesn't stay in contact with you. She gets out. We don't see her again. If you want, we can, you know that 100% that she's got court March
She
14th.
does. I talked to her mom and I've been in contact. Her mom says she's gonna stay in custody and after that,
So let's do this. Let's set it for the 15th, assuming that's not a Friday that's a Saturday. So set it for the 17th and then just keep us in the loop.
Yes,
We'll
Judge.
make her appearance required here on that day. Perhaps I'll give her time served and then just let mom know that we've set it for the 17th here. If she fails to appear on that day, because I'm going to set it for bond forfeiture, then I'm going to revoke the bond. But if
Okay.
she comes, then all's well.
and if she's still in custody, we'll just.
If she's still in custody, then we'll just carry it and keep like what we're doing.
Yes,
Yeah?
Thank you.
Okay.
Very
for sure.
excused.
Yes, ma'am.
Thank you.
Yes.
Yeah,
So for the bond violation, we doing continued supervision or? hold?
correct. Yeah.
Thank you.
Okay. Hi.
Judge, we're here to approach to see if you'd consider a bond on a fugitive case for My Win. She's a female.
You can bring her out.
Yes, but would you mind bringing out female My Win? And then while he's bringing her out,
Oh, right. Sorry.
Oh,
Xenon Reyes.
Let me give you an off docket case. I'm good. 254-8869. So this one's actually set on the 10th for a pickup, but Arkansas actually came yesterday to pick him up. And unfortunately, the defendant ingested something of an unknown substance that had to be taken into medical. And so Arkansas waited around for a few hours, and obviously they didn't know when he was gonna come back to the holder to the jail. And so they went back because he was hospitalized.
are they still getting that paper stuff? You know what I'm talking about? Remember that was all
I
this?
saw that. I don't know. I just do.
You know how people are now taking dope in the jail because they're getting,
You mean I don't know, and part of what I want to figure out if it was something that he did intentionally to force or prevent extradition, like he was doing it because he didn't want to go back, or if it was an
did he
unrelated.
know that they were coming here to get him?
I don't know. I have almost no information except what I presented to the court. But in that same vein, I asked when they're able to return because they have, connecting pickups that they have to do. So they can't just, come right back. They have to go in order. And so the next time they said they could pick up was
I'm not opposed to it because, I mean, it's through, they came here.
How long is it for?
It's next week. I think it's the 12th.
So
On the 12th. And so
Okay.
the court date would have to be the 13th.
Yeah, I'm okay with it.
Okay.
It's not their fault, right? They'll have to make a double trip now.
we'll put it on docket for the 13th, pick up by the 12th?
Thursday, to pick up at 12.
Yes.
Yes.
Good morning, Ms. Nguyen.
Good morning.
Your lawyer's asking me to set you a bond. I don't know. I have to get to know you. My concern is whether you're a danger to our public and whether you're going to go back to the jurisdiction that you're wanted from. So Mr. Kim here is going to tell me all about you. We'll get to know you to see whether that's going to happen or not. Mr. Kim?
Judge, this defendant's wanted for 3 counts of insufficient funding of a check or issuing of a check.
Wow.
She wanted
Quickly.
out of Garcia Parish and Cano Parish. And the reason why I point out both is the original teletype came in for Cano, but whomever the arresting officer put Garcia, but at least one of them is in the amount of $30,000. So it's not a small amount.
Okay.
That said, they are non-violent offenses, but it's whether she will actually self-surrender to the demanding jurisdiction, I don't know. This
Any
warrant
priors?
is from 2023, or at least the checks are from 2023. I don't know when the warrant was issued.
Do you know if they're 2Bs or was she?
Oh, they would have to be QB. It's relatively recent, but I believe the check issue was in 2023, or at least one of them. I can't speak to all of them because I haven't gotten the ones from Garcia. I've only gotten the one from.
Your Honor, I have the boss here. I called them this morning. They said the amount is about $96.
Okay.
I was,
Yeesh.
Yes.
like I said, $96.
All different.
Are you opposed to a bond?
Now I'm opposed.
So, I mean, our purpose is not to litigate Louisiana stuff. She's 42, clear criminal history. I've confirmed with her friend who can make her bond and take her to Louisiana. They're going to drive. We have a plan. Never been arrested, didn't know about the warrants, no FTAs.
I'd argue the fact that she was able to manipulate over 120,000 some odd dollars.
But that's for them to litigate that.
But
You know
in
what I
terms
mean?
of
And
the
they'll,
risk of- I mean, making the bond is obviously a non-issue if what she's being accused of was.
I don't think it's violent though, so who cares?
I'm okay with the bond.
Okay, well, would you consider a PR bond?
No.
Okay, had to ask. Okay. What amount of bond are you thinking?
Okay.
Be the same amount as before, just because of the sheer amount that was alleged and the fact that it was in two different parishes.
All right, I'll do the same, 2,500.
Okay.
And then, has she already waived or no?
She did waive, so I'll do a waiver withdrawal. Do you prefer?
Make sure that they can do it first, that way they don't.
Pay the
give
bond?
it- Yeah,
I'll verify it. I'll
yeah,
call.
that way, in the event that they're unable to, they don't lose all that time, So, and then just let me know if yay, then that 20,000.
Okay,
Yes.
thank you.
Thank you.
Oh, wait a second. No. I still have to monitor that.
Oh, yes, of
And
course.
you need to understand that if you post this bond, we give you 14 days from the date of your release to go turn yourself into Louisiana. If you fail to do that, I'm going to revoke this bond. I will set it at 0 and I'm not going to do this again. So if you take off, I'll revoke the bond, issue a nationwide warrant for your arrest. I'm going to get you back. And this time I will hold you until Louisiana comes and get you. And I will not set you another one.
All right, thank
You
you.
understand? Okay, ma'am. Good luck.
Thank you, sir.
Thank you. Okay. Hi.
Morning, Judge. How are
Hey,
you?
what's up?
Judge, I have Mr. Haid Brian Martinez.
This was
He
a,
did a plea. He had the bond violation, so you put him in custody.
correct. Is he still back there?
Still in custody. I know he has a bond. My understanding from talking to Marcus about this case was that you want him to get T-rest and do some sort of.
Yeah, so we were gonna do a TRAS today.
Judge, Shatoria said they said the assessment would be ready around 10:30. They completed it, Judge. It came back community residential followed by the high-risk caseload and IOP SOP.
Okay. So if you'd like to go through with it to see if that's what he would like to, I typically like to follow the TRASs because every time we don't, we get burned in a really big way. So, see if that's something that he's interested in. If not, we'll have to.
Yes, Judge. Because of the ICE hold issue, I saw that he doesn't have an ICE hold. I'm gonna tell his family to just bond him out because I saw that there is a bond
It's
amount.
up to you guys. Yeah,
And then-
whatever you'd like to do.
Talk to him at length and bring him court to plea out.
Okay.
Thank you, Judge. May I be excused?
Absolutely. Coming up, counsel.
Morning, Your Honor.
Okay, who do you have?
Mr. Kabir is for the bond violation.
Okay, come up, Mr. Kabir.
That's right here on the back.
Yes, absolutely.
This position said you should consider.
All right, quiet in the courtroom. We're going on the record. Ready, Ramona?
Yes, we are.
All right. We are on the record. Today's date is February 7th, 2025. It is approximately 10:35 in the morning. We're here on a Fizan Kabir, cause number 215-8240. Guys, would you announce yourselves for purpose of the record? State.
From the state, LCC, from the state, Mackenzie Watson.
Defense.
For the defense, Andrew Salinas, Salinas.
All right. And we are here now due to Mr. Kabir having a bond violation. This is our third bond violation report that we have had. Our first bond violation. So I guess let me start up. Mr. Kabir is charged with driving while intoxicated. He was ordered as a condition of his bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
He currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
So we put conditions on him. I can't. please, Felicia?
The most recent ones, Judge, or there's been a few that we've amended over time.
What are the current conditions now?
The current conditions now are. A hearing report every time the case is set on docket, there's no new law violations. Install a IID device in the vehicle, no driving without permission of the court, no drugs, no alcohol. Plan to obtain a scram device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6th, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond violation. And in this violation, the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event that occurred on January 16th of 2025 at 11:55 p.m. It was also confirmed by a scram analyst as well. Correct?
Yes, Judge.
Okay, so.
Yes, Your Honor. So,
Yes.
yes, so to begin with the first amended order for pretrial, so if the state wants a copy, I have a copy to show them, but sure. So, Your Honor, just going to the very first order, as Your Honor just noted, usually agency fees are waived for that. However, the box on that for saying that the fees were waived, I believe were not checked on that. Further, Your Honor, the main purpose here for your determination of giving someone bond in the first place is to establish that they come back to court. So are they a flight risk? And then also, are they a danger to the community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I can call a witness to testify that, but I know that you
But that doesn't
are aware of
excuse you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that you can just?
No, Your Honor, I'm trying to contextualize this because we've been here two prior settings before. I know you're concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second, there was no indication of alcohol consumption or drug use during that time.
It wasn't working. How are we supposed to know?
And Your Honor, again, one of the two main points of determining what kind of bond, both the conditions and amount are, will they return to court and community safety? Here, my client who's being accused of DWI wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by Scram, but no one is here to testify on behalf of. Well, we can call that, Your Honor, but sure.
Judge, I spoke with the defense counsel today and he said that he was not requesting to have anybody come here to testify to the scram device.
We have Felicia that can be called up as a witness to testify as to what happened with and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did that. So that's, yeah.
Please.
Yes, Your Honor, we would call retrial services, Ms. Felicia Charles.
Okay, ma'am, would you please come up, raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
So you have first amended order and then second, third amended pretrial supervisions and then the fourth. So referencing the fourth amended order for pretrial supervision and bond conditions, what I'm showing you, do you recognize this? Yes. Can you tell us what this is and what are the conditions that are checked? These are,
Sorry, could you repeat what you just said?
sorry, I said I don't know if she needs that. It was an extra paper.
Okay, I just want it on the record.
Sorry.
Thank you. That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new, law violations, install ignition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain. We do have a curfew of 9 PM to 6 AM, and then a scram device to be installed. And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
Admitted as one.
So in this case regarding the scram device, can you tell us about that? Yes, so what exactly about? What is that? What's the standard procedure someone's supposed to do? Yeah, so a scram device is ordered and it tracks the press.
Objection, Your Honor. The foundation, I believe the state is trying to ask her to testify as far as are you trying to establish her as like an expert on scram?
And I was not trying to establish her as an expert, just from her experience, what the scram device is basically for, which she can testify to as a trial.
I'd ask that the court consider that as that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there is a violation for alcohol consumption. So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph. And I'm showing her now what's marked as state's. For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay, please.
Have the graphs been printed, state, or she's just referring? Yeah, just so we can all agree on what she's referring to.
And I'm showing you what we marked as state's exhibit 6. Can you please tell us what this is? So this is a scram report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per. Okay, so this fairly accurately depicts an scram for and that it says this. Yes. We will tender defense for any objections and note that this has been, is it correct to say this has been emailed to defense prior to this date? Yes.
Defense received it, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the scram was not completed properly?
Yes, so the device seems to be fully functioning. And on January 17th, sorry, Friday, January 17th, the scram device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 a.m. on January 17th. Say it again. 9:05 a.m. January 17th, 0% TAC was reestablished for the dissipation of alcohol.
Okay, and for those dates, the ones that match on what I'm showing you as Case Exhibit 2, the bond violation report, can you please, do you recognize this?
Yes.
Can you please read the details of the violations here?
It says the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 p.m. This information was received on 1/17/2025 and confirmed by a scram analyst.
Thank you. We pass the witness.
Okay. All right. Good morning. I just want to, if you could turn to, I believe it was the State's Exhibit 3, I think, for the scram non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay. Would you stay, since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
No.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
So
thread that was provided.
let me, sorry, that was a poorly phrased question.
I'm sorry, I
No,
don't understand.
that's my fault. Don't worry about it. My question is, did she consult with you when compiling this report?
Could you be more specific?
Did you help in the assembly of this report?
No.
Okay. Have you ever assisted or aided in the assembly of a scram systems non-compliance report?
No, no one.
No, no one in the department does. Okay. And do you have any sort of, have you ever worked for scram systems?
No.
Have you ever had any special training in scram systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but not expertise.
Sure. And what exactly did this person teach you?
We went
Briefly.
through how to read the graph, kind of how to establish consumption versus a tamper, environmental factors versus consumption, et cetera.
Okay. So during that training, did you ever actually look at a physical device, the scram device?
No.
So you didn't do any like live experiments where, like, for instance, you put on a scram and then, drank alcohol to see how that works?
No.
No. Okay. And as far as Mr. Kabir's scram device, have you examined it prior to this hearing?
Me personally, no.
Okay. And so one second. So is it fair to say that you've been thoroughly trained on the theory of scram device and alcohol detection? Is that fair to say? That let me rephrase that. So you don't have any actual technical experience with how the scram device detects alcohol in someone's skin. Is that fair to say?
Thank you.
I don't want you to think. It's a yes or no.
I still don't understand.
I'm trying to understand too.
Do I not understand how a scram device works, or have I not for myself and
Sure. So, this is pretty, is it fair to say like the science is kind of advanced here? Like when you received your training, did you have the personal opinion that that was advanced science that you were learning about?
I believe so.
Okay. And you don't, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I
We
partially
did
wrong
go
about?
over, yes, reading the graphs, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially as well with tampers, environmental factors with that, makeup
Mhm.
or, placing something between the skin, how things are worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no withdraw that question. So I'm just saying there was no actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it, so we examined
Good.
the report for that.
Well,
And also reviewed some of the peer-reviewed articles.
Well, that's great. I'm glad that you want to, a lot of people won't. They'll just kind of do their jobs, right? I'm glad that you want a further knowledge, but what I'm trying to get at is it's fair to say that knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? Do you agree with that statement?
Yes.
Okay, so without actually having examined in your own personal observation, how a scram device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Question asked and answered.
Okay, just, let's go.
All right. Just answer the question. I don't know if that was an objection or sustained or
Let's
overruled.
just move on. I mean, we're here to see, is there a positive blow or not? She's testifying that there was.
Sure. I'm just saying that I'll make my argument in closing. I don't have any further questions. Thank you.
Okay, closing, or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the scrum device has been tampered with?
Yes, we get notified of tampers and consumption events.
And you get notifications if it's been cut off? Like, just what's been going on with the scrum device? You get those notifications?
Yes.
Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a scrum device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened at January 16th of this year at 11:55 p.m. And this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated the order, was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be detected.
Okay.
Yeah, Your Honor, I agree with state insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say again.
These devices are used all the time.
Well, their use all the time is
Just so-
irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
We have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well?
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Here this week.
that wasn't, are we still on the record then on that? Okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself, on whether it tests cannabinoids, which Delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any Delta whatever. Regardless, it's number 3, goes with you. Off the record. Sorry. Thank you. But I just can't, with an open DWI and a third, that's it. I can't just keep doing it, you know? At some point, I become an enabler and I can't do that. I can't keep doing it, you know? So.
Well, I mean, Your Honor, I understand you're revoked the bond. Would you consider raising it to?
Well, I am going to raise it, right? I'm going to raise it to 7503 now.
Well, and look, I'll just, if you could take this into account, Your Honor. This is a hired client. You know, he has every intention of taking this case to trial. So I would, you know, just, I'm not Chief, Your Honor. So if you could keep that into consideration on that.
It's, you know, and it's.
I understand.
Representing him in Navarro too?
No, I'm in touch with his counsel there, but no, I'm not representing him there.
Okay.
Yeah.
But tell him this, that he's lucky that they didn't revoke him on the first 2 cases, considering that he has an open, you know, really, because, and I'm telling you now, I don't know how I didn't, but I can't just keep doing it. I can't.
75.
7503. Yeah.
Judge, quick on this one. I should have called her up. She failed to appear on her,
Just don't worry about it. It's still.
or page 14 case.
And then hold on, I have a lawyer here, Mr.
Oh, yes, I emailed him, top of page
Oh,
13.
Mr. Garcia.
13. Top.
Yes, Judge.
So I didn't know who you are. I'm sorry, but thank you for putting the attorney so that way I know it's you, you know, and I can look you up.
Yes, Judge.
So where's your guy now?
My client, as soon as he was released by the sheriff's office, he was taken into custody by ICE, to ICE. And I'm here to see if the court would reschedule this hearing so that I can try to get him out of ICE hold and ICE detention and have him appear back into your court. What I'm asking in short is for the court not to revoke his bond. Otherwise, it's going to make it nearly impossible for me to get him bond out of
Mr. Garcia,
ICE.
I'm happy to do that, but I just want to make sure I need proof that he's actually in ICE custody. So if you could perhaps email Victoria, my coordinator, usually they have that master docket sheet on the ICE website that will show that they're actually in ICE custody. If you can send that to Victoria, I'm happy to give you a reset until after that master docket hearing. But I just want to make sure that he's actually in ICE custody and not just out and about.
I will do that immediately, Judge.
Okay?
Yes, Judge.
Thanks. Okay.
Thank you.
Hey, but what was the last name again?
Riley.
Riley. All right, Mr. Riley. So you got to understand that actions of consequences, right? I'm setting your bond at $1,500. This is allowing you to be able to go turn yourself into Louisiana, right? I'm not going to play this game with you again. You're old enough to know that actions have consequences. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. If you fail to do that, I'm going to revoke the bond. I'll set it at 0, and I will not do this again with you. I'm going to arrest you again because you can't run forever. And this time I'm going to hold you at 0 bond until Louisiana comes to get you. Do you understand? All right. So bond set at $1,500. All right. Best of luck to you, sir.
Thank you.
Okay.
Is that his?
Yeah, I'll get you a copy right now.
Judge, can I call up?
Oh, yeah, let's do it. Sorry, I have an arraignment real quick.
Page 14, Chase, come on up. Yes.
Look up here, right here. We may have it right here. Yes.
All right, thank you, Jack.
Hey, how are you?
Is that it or?
Good morning, Ms. Pace. Ma'am, you were charged with the offense of prostitution. You're facing up to 6 months in jail and or a $2,000 fine. Shh. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Oh, thanks, Day.
I can read it.
Ace. Hey, can you reach out to the man,
Right.
please?
January 28th at the Embassy Suites at 2911 Sage Road, Houston, Texas. Defendant agreed to perform rear entry straight sex and other deviant sexual intercourse act with a fee of $200 with law enforcement officer. While participating in proactive state carrying prostitution, the law enforcement officer responded to an advertisement offering prostitution. The officer tested the listed number. Defendant agreed to meet at the hotel for a fee of $200. The officer met me at the hotel, agreed upon hotel, and he agreed to perform sexual intercourse, oral sex, and rear sex for a fee of $200. The law enforcement officer gave a signal.
And I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to engage in this type of behavior again. Do you understand? I don't want to have to put you in jail. You're now on your second case. I mean, what I'm going to do is I'll have you take a seat in the jury box. Let me find you a lawyer and we'll have you talk to someone today. All right? Please. Can I give you a court-appointed lawyer, ma'am?
I want to look my own lawyer.
You're going to hire a lawyer?
I've already done it.
You sure you don't want a court-appointed lawyer?
Oh, so I hired a lawyer for the ticket, and he's gonna take on the event.
If you pick up a third case, I'm going to revoke all of your bonds and make them extremely high. Do you understand? 3 strikes, that's it. I'm gonna have you sign a receipt of Victoria. I'm gonna have you then take a seat in the jury box while we get your bond conditions. We'll have you sign it and then you'll be on your way, man. Okay?
No.
She wants THA. She doesn't want a lawyer.
Okay, I'll make the request, but there was one more that was transferred from court 4. Can I give you the case number? Right this way in this case,
What is it?
2549795.
Indictment?
Yes.
Did you get it?
In arraignment?
Tell me when you're ready. Okay. 254-9795. Aquan Dykeman, come up.
All right, go ahead and have a seat in the jury box behind you.
2549795.
Yeah, 254-9795. Mr. Dykeman, you are charged with criminal mischief. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officer was dispatched to a family disturbance call in Harris County, Texas. The officer made contact with the fighting witness, indicated that she was in the bedroom. The defendant came in and asked her for money. Fighting witness told the defendant she didn't have any money. The defendant then lost his temper and grabbed the fighting witness' laptop and threw it across the floor, causing damage. The defendant also grabbed the internet modem and threw it, leaving a hole.
Do we know whether she wants to have contact with him? Do we know whether the complaining witness wants to have contact with him?
So no, print it out.
Not,
Mr. Dykeman, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? Yes or no?
Yes.
If you violate these conditions, I'm going to revoke your bond. I'm going to put you in jail. No more PR bonds for you, sir. Do you mind filing those conditions, no contact and no weapons, please? You're also not to be in possession of weapons. You become a danger to my community, I'm going to put you in jail and I'm going to make your bond high. Do you have the ability to hire a lawyer? Are you working? I'll have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. I need to know how much money you have in the bank, how many bank accounts, stocks, bonds, IRAs, everything about you, whether you drive a car, what kind of car. Do you understand? If you leave it blank, I'm going to send it back to you. Do you mind giving an application, Deputy Moran? I'll have you sign a reset and then wait, have you take a seat in the jury box, sir.
no contact.
No weapons.
Just sign your reset, please.
Okay, are you ready?
Yes.
Come on.
Judge, this is again Mr. Martinez. He's gonna come back on the 11th to do the plea, but on the 10th, he has to go to Tarrant County. Part of his conditions of bond right now is a curfew. He has to go to Tarrant County to do the TRS there for his case over there. And he's worried he's not gonna make it back in time by 9 p.m.
So set it for the next day. It doesn't have to be on that day, set it for the day after or the day after that. It doesn't matter to us, right? But he can drive with,
No, I know. He's gonna be here on the 11th. His problem is, because he has the curfew, he doesn't want to violate. He was wondering if you would lift that so that he can go to Tarrant. No?
I'm not gonna I don't want him out in the middle of the night. You know
Okay.
what I mean? You can drive in a manner that you're not gonna violate the curfew. I don't see why I need to give him access in the middle of the night. That just doesn't,
Okay, so if he runs
he's
a
got
little
two
bit,
open DWIs. The last thing I want
Judge.
is in the middle of the night.
yes, Judge, so just stay in Tarrant and then come back the next day.
Yeah,
If
I mean,
anything.
Pat, if you wanted another reset farther off, I'm happy to do it.
Yes,
Really,
Judge.
it doesn't,
Yes, Judge, I'll talk to him. If for some reason he isn't able to come back on the 11th, I'll let the court know and then we can roll him.
that's not a big deal.
Thank you, Judge. Maybe excuse.
Hey, Mr. Sims.
Judge, I'm approaching Enrique Flores. And on this one, Judge, he has a bond violation. I think he has an interlock and a scram device.
Mr. Flores, come up.
And Judge, he was on a work trip in San Antonio, and I think that's why he didn't get his interlock calibrated. And I think there are uploads that need to be done with internet, and so he's gotten his internet situation fixed. You do construction?
Is he still in lockout?
I believe so.
Yeah, I mean, you gotta abide by the bond conditions. Why should I not just put him in jail now? He doesn't have an interlock.
Well, Judge, he has a scram device in an interlock right now. Do you have, is that a scram device on your ankle?
Any violations? And why is it in lockout? I mean, I'm paying for it.
It's just not the lockout is due to not go into the facility to get the device recalibrated.
Okay, so I'm sending him now to I'm
Judge.
sending you now to the facility. If this happens again, I'm gonna put you in jail. Do you understand?
Judge, thank you, Your Honor.
Okay. So I'm rolling this to Monday to make sure that it gets done.
Yes, Judge.
Wherever your point is.
Can he waive signatures? I believe they took them. Or, so your pretrial officer wants to reinstate the bond conditions, but she needs a
Okay,
signature.
waive the signature.
Yeah, thank you, Judge.
Yeah, hey, I'm not reinstating his bond.
No, I know, but
Just the
since it's
conditions.
revoked, I'm just
Right,
putting-
okay, all right, come on up. Hey, what's up, man?
Roberto Castro, it's a new case I was appointed on. I believe we need bond conditions, I believe.
Mr. Castro, come on up. You seem like such a nice guy. Why does this keep happening? Mr. Castro, really? You're now charged with another assault. You're facing a year in jail and or a $4,000 fine. So what happened? Please.
Judge, on February 1st, 2025, approximately 12:43 p.m., officer was dispatched to Cypress Creek Hospital, Houston, Harris County, Texas. On arrival, officer met with complaining witness who stated she was assaulted by another patient. Complaining witness stated she was walking out of the room and the defendant started yelling at her, back up, back the fuck up. Complaining witness stated she was confused in a verbal argument. Defendant struck complaining witness to her face, causing pain. Complaining witness had laceration on the inside of her upper lip. Police stated, defendant stated that they got into an argument, and the complaining witness got into a fighting stance. Complaining witness won't get his hands.
Mr. Castro, don't go back to this hospital. Do you understand, sir?
Yes, I guess. I'm not allowed back there. I don't much have anything off that hospital that happened with that.
I don't want you to pick up any new cases.
Yes,
Nice.
I'm continuing to do that today. But interestingly, I guess, though, you're lucky.
Listen, I'm giving you a lawyer. Just stay in contact with him. He's usually pretty good about staying in contact, okay? Don't pick up any new cases. I don't want to have to put you in jail, all right? Just be nice when you're out there. All right, we need him to sign conditions and then you guys are free to go, okay? All right. You mind filing that? Please, no contact with the complaining witness and no going back. Lori.
Sean Benjamin Webb. He's in custody. He is charged, I forget what he's charged with, but he picked up, this is a new offense and I have to.
So Webb is the last name?
Bernard Webb.
Oh, right.
But he's in custody.
Yeah. I remember we were talking about it yesterday. So the deal is this, is that, they gave him a PR bond on the first case?
I'm not sure, this is Ariel's case.
So we have him on the 12/19, he picks up a terrorist threat and assault of a police officer. 2 weeks later, a false report to a police officer, and now he's picked up a less than a gram case. So the only thing I was gonna do is just revoke on the first case and then leave. They didn't give him a bond on the first case, so he's got a $100 bond on that one. I'm just gonna revoke and set the other one at, 5,004. And that's it. Okay?
Thank you.
Thanks.
Oh, yes, I did.
So hey, on the page 19, on Bernard Webb, on the terrorist threat, 5,004. They do that now. Connor.
Hey, Judge.
Hey,
Working on Ramon DUS.
okay.
So
We need to have a talk about this.
I know, Judge. He just pled in felony to 6 months state jail. They dismissed his misdemeanor indecent exposure. We still have the trespass probation that he's on. I think he has maybe a month left-ish on the 6 month sentence.
Great.
So
That's great, because I don't want to let him go. You know, the last,
Leonard? Leonard?
if I let him go, my feeling is as soon as he gets out, he's gonna be right back over here. And then we're gonna be doing the whole dog and pony show again, because what's gonna happen is they're gonna give him another PR bond, not gonna come back. He'll get another PR bond, not gonna come back. He'll get another PR bond, and at that time, maybe, you know,
yeah, the only thing, Judge, he has been in custody pretty consistently for over a year. I don't think he wants to be in jail.
how long has he been in, you know? Can you check on, justice?
Because we sent him to DDRP, I believe, like at the beginning of his probation, which I think was the end of 23. And then he immediately skipped on that and has been in custody since then. How many days?
What do you think? What do we do?
We could send him back, but the only thing is a misdemeanor, we're limited to what mental health facilities we have. And the wait list is a little.
And the thing about it is, we know, like now, when he's picking up felony cases, they're not gonna put him in a treatment. They're just gonna get now. I mean, like this last time, he's gonna get state jail. If the state jail, was that from the unauthorized absence?
Believe
Or was
so.
it from?
He also had an unauthorized use of motor vehicle. I think that they may have done
Really?
yeah. I'm not on those cases, but I believe he got it on the.
I guess I'll unset term, and then we'll start doing it again. When, yeah, if and when it happens. Okay,
Does he need to do a plea, Judge? No, we're just gonna.
just unset term.
Okay, cool. Thank you, Judge.
Okay.
Judge, bottom of page 18. What you got tested is back. I don't know what you want me to do with that one. There's no attorney attached.
A point of order.
Okay, and then counsel, that's his, he's still on Zoom.
Okay. So Mr. Garcia,
Yes, Judge.
so it says that your hearing is the 25th of February. Do you want maybe like a week after? What do you want to do?
As much as I can get, Judge, a week or two after would be perfect.
Okay, just to let him know, please, that if he does get out on bond over there, we need him here for bond conditions. And then after that first setting, I'll waive his appearance. But if he fails to come here, I'm gonna revoke his bond, huh?
That's more than fair,
Let him
Judge.
know.
That's more
So
than fair.
give me a day you want. It doesn't matter to me. Just anything but a Friday.
I'm checking my calendar as we speak, Judge.
Judge, you said a week after what, Monday?
A week to 2 weeks, whatever he wants.
I am available, March 5th, Judge. Is that something that the court can give me?
Yeah, I'm okay with it. So that is a required setting for him here if he does bond out. If he doesn't bond out on that day, just let us know. We'll carry it. And then but if he doesn't show and he's out, he gets revoked, okay?
Thank you.
Okay, man, you got it.
May I be excused, Judge?
So did you get that, Victoria, did you get the date? March 6th?
March
No.
5th, I believe.
5th, 5, right?
5, yes.
Okay, yeah. All right, take care.
Thank you, Judge.
You too. Herman.
Judge, for Brian Martinez, when the attorney was approaching about the curfew, was there a day that we said would be okay him not?
Oh, I'm not taking off the curfew. Yeah, he has two open DWIs. Hey, we need to bring homeboy out, Mora. Did you do Mora or no? The waiver? Amy, who had Mora?
I did, Judge, but, yes, I'm ready.
Do you need to translate?
Yes. One's been called.
April, did you want one or both of them?
One interpreter? No, you want to bring the one to out? It's up to the audit. Well, they're not ready yet for the police. They are ready from what? They can go viral again by doing it all in Spanish. Look at that. Just in time. How are you? I got Extradition, I got Junkies.
Dame los números.
Los números de
Todos.
Mora is. Yeah, case number, Amy, right there. I thought I had it right here.
Yeah.
255. Uh-huh.
That's Mora.
Okay.
No, the other one's right here. So we're done.
Buenos días. Vamos a escuchar. Escuche.
Okay, are you Nelson Mora?
Yes.
Mr. Mora, you are wanted out of the state of Oregon for sexual abuse in the first degree, 5 counts of it. Are you waiving formal extradition, sir?
Yeah.
All right, sir. Good luck.
Buena suerte. Te pone el agua así.
¿Ya está con todos? Vete con él. The other two are. 4-6.
256.
No, I'm sorry, 2-4-6.
Okay. 2, 4, 6.
0-4-6-1.
0-4-6-1.
And the other one is.
Mr. Elick, how are you, man?
250.
Friday.
2633.
I'm ready.
263.
Oh, hold on. Did you need something else?
I need them to be brought out, Judge.
Is this Concepcion yours?
No, Judge.
Is Concepcion yours?
Yes.
Okay, you ready? Ready? Do you need a translator?
No, no, okay.
I'll tell them to bring it. But we're waiting for you.
Good morning, Mr. Concepcion. So you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. Is it on docket today or no?
Not on docket.
Okay, that's what I was, okay, so it's a straight probation as well.
It is, Your Honor. I asked for deferred, but we settled on straight. He's on deferred on a felony.
Perhaps that's why. All right, let me see.
He did miss court a few weeks ago, Your Honor, so there was a warrant.
Is there a felony warrant right now?
No, there should not.
Sure.
They
reinstated like his probation on the 9th of January.
And he has been meeting with his probation officer.
You need to understand something, that you're on probation for an extremely serious case. You're looking, I don't even, is it a first or second degree?
I thought it was second degree.
I think it's second.
Secondary probation.
You need to understand these types of probations, when you get revoked on a second degree, you're usually looking at double digits, probably 10 to 12 years in prison. Do you have any clue what they would do to you in prison? No, you don't. Have you been to prison before?
So
You're a potential, how many times have you been to prison? Once, twice?
That's
You
once.
could be a potential 15 to life case from now on, man. You know, really. Not only that, it's a 3G. You get revoked, you're doing half the time before you're even eligible. There's only so many times that they're going to reinstate before they start throwing the book at you. You know what I mean? Really.
Yeah.
So you've worked out an agreement where they're offering you 1 year in Harris County Jail to be probated for 6 months. As part of the agreement, the only thing that you have to do is stay clean. Literally, it's the only thing you got to do. Can you do it?
Yeah.
If you don't, I'm going to put you in rehab myself. You know, really. Not only that, but depending on what you're taking, you take too much of it, all you're going to do is put your lungs to sleep and you end up dying. We see it happen here all the time.
Sure.
You build up that tolerance, you keep taking it, and then, you know, you're chasing it, right? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this, there's no changing. You understand?
Yes, sir.
This is what you want to do. You know, I got a figure of all your criminal history here. I wonder how much of it is related to. You know? You're young. Get off. Do something else.
I just turned 30 years old.
Really. And this,
Yeah.
all right, how do you plead to the offense? Guilty or not guilty?
I'm
I'm going to find you guilty. I'm going to send you to the agreement. If you want any help, come back and we can help you out. All you got to do is ask. But if you go out there, if you take off, you pick up a new case, you test positive, I'm going to put you in jail. I'm going to issue a warrant for arrest. We're going to bring you back. We're going to have a hearing. And if they prove it to me, you're looking at a year in jail. Do you understand?
Sure.
All right, man. Good luck.
Thank you, Your Honor.
Got it. Victoria, test in 2 weeks.
¿Quieres Cáceres? Porque se puede firmar en la capilla por favor. Ahorita no va a pedir su huella en la capilla. No. Ok, si puedes tomar de nuevo porque no tomó la primera vez.
Actually, we have a client who's coming for an admonishment because he didn't do IOP, SOP, and DWI. He's providing me the certificates for both the IOP and SOP. He's showing proof on his phone. He's enrolled in the repeat offenders class and it's going to be done on the. Yes, I did with the probation officer this morning.
Okay, ustedes saben.
I didn't know if you wanted to talk to him or if you just want to have him come back maybe in 2 classes a day.
Yeah.
Okay.
Yeah. How many people have I taken into custody today? Just Kabir and Driver, right, that's the other one. Okay, thanks, because I need to do a thing on.
Okay. Sí, puedes. Ya. ¿Quién es Rodríguez? Okay. Fíjese que se acaba de poner la transmisión de la Shriber. No, señor Rodríguez, si puede poner su lugar derecho en la luz, pero manténgalo en medio rueda. Muchas gracias. Sí, por favor.
Okay, so thanks. Good morning, gentlemen.
Rodríguez en Cáceres.
Good morning, gentlemen. Both of you have picked up criminal cases. Both of you have worked out agreements. That's why you're here in front of me. Both of you guys have elected to plead guilty. What you guys need to understand is these charges will go on your record. They're going to be there for the rest of your lives. Mr. Cáceres, you are charged with criminal mischief. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 60 days in jail with credit for the, is it 60, right? 60 days that he's done. Mr. Rodriguez, you are charged with evading arrest or detention. You are facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is 12 days in jail with credit for the 4 days that you've done. You need to understand that your case, Mr. Rodriguez, well, both of your cases are enhanceable offenses. You, from now on, Mr. Rodriguez, if you ever pick up another evading arrest, you will be facing a felony charge, years instead of days. You pick up any more misdemeanors, it is a minimum of 90 days in jail. Mr. Cáceres, yours, from now on, you are facing a minimum of 30 days in jail for any new cases that you pick up. Both of you are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you guys are not citizens, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. And like I said, you give up the right to appeal. Do both of you want to continue to go through with this today?
¿Quieren continuar con esto? Yes.
How do you plead to the offense of criminal mischief, Mr. Cáceres? Guilty or not guilty?
¿O no culpable? Guilty.
Mr. Rodriguez, how do you plead to the offense of evading arrest or detention?
Guilty.
I will find both of you guilty, sentence you to the agreed upon punishment. Good luck to you, gentlemen.
Buena suerte, señores.
Thank you, Judge.
Pueden ir con el agua, sí.
Sí, se quiere.
Buenas suerte, muchachos.
Hi, Harold.
Hey, Judge, good morning.
Good morning.
My approach, I just want to apologize for not being there this morning, appointing me a case.
That's why we have Zoom, just for you.
I got stuck in another court and I couldn't even Zoom. And I actually sent the notification to court 7. In the wrong court. I thought I was assigned.
Don't worry about it. That's why we have it. You're good to go. I'm happy
But
that you showed.
I did let the MAC know. So, and that's all, they canceled the first appointment. So, but I'm headed back that way. Are y'all done already today?
We're close.
Okay.
So tell me who you got today.
No one. I just had Miss Lerner, Molly Lerner, but y'all had already voided it. So it went to someone else.
Reappointed judge, so as of right now,
Oh, it got reappointed, so don't worry about it, Harold.
Okay. All
You're
right.
good.
Well, thank you so much. And
Yeah,
but,
we'll let you know if something else comes up.
yes, sir. I'll watch. You have a good weekend, folks. To talk to you.
Take care.
Thank you. Bye.
you grant those, Señor Romero?
Yes.
Okay.
Hey, who gave this to me?
This is great.
Huh? She told me? Oh, that's the.
Yeah. Just know that she's.
Oh, Shriber?
Yeah, oh.
You right-handed or left-handed? I make sure you talk so that I can hear you. Okay.
Yeah, look at you, Lori. What a day, huh? Busy day today. You're earning your keep today.
If you can give me your signature for your backpack. Okay, next, if I can get your right thumb clear, let's move tonight, next time at home still. Thank you, sir, you're out of me.
This is Trajan Edwin, Judge.
Okay.
Trajan, I'm sorry.
Good morning, Mr. Edwards.
Edwin.
Oh, Edwin, I'm sorry. I'm on my fault. All right, so Mr. Edwin, you're charged with evading arrest or detention. And criminal trespass. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 21 days in jail on the evading credit for 7. Is this what you want to do, sir?
Say that I'm getting out tonight.
Yeah, it's time, sir.
So time serves is very sexual to me. Thank you so much for it.
But you need to understand, this is going to go on your record. If you run from the police again, they can charge you with a felony offense. Do you understand?
If our Salveria toll licenses does not want me to get in trouble like this again.
I didn't hear.
Salveria toll licenses does not want me to be acquitted and being in a judge's face like this again.
He's saying somebody doesn't want him to get in trouble again like this.
You know what we're doing today, right?
Today is the lawyer's offense of licensing me to get out of jail, yes, sir.
Well, you're pleading guilty. Is that how you understand it?
I'm not necessarily pleading not guilty, yes, sir.
Are you guilty?
I am fully registered to be guilty.
What happens if you pick up another evading arrest?
You are resourceful and knowing to not do it. So we don't.
What do you say?
He said we are resourceful to knowing to not do it.
Okay, Don't. You can get a felony next time. Do you understand? All right. You're giving up a lot of rights by doing this today. You don't want a trial. You don't want to talk to witnesses. You need to understand that there are consequences. It will go on your record. It will be there forever.
Just be like Salveria Toll Licensures. I am just be like I am the CEO of Salveria Toll Licensures, which means I am a lawyer.
Let's
To understand that.
let me reset it, Judge.
We do not want to get in trouble.
Let's go back.
We're saying we do not want to get in trouble.
I want to make sure you understand. Mr. Edwin, we just need to make sure you understand what's going on. Okay? You know that you're pleading guilty to this offense.
Yes, sir.
Yes, sir.
Do you know what that means?
Taking convictions.
Right. So you know that this charge will go on your record, correct? If you run from the cops again, you'll be facing a felony charge. You understand that? Okay. You also need to understand that by pleading guilty, you are giving up many rights. You don't want to go to trial. You don't want to talk to witnesses. You don't want to confront, cross-examine the people who are accusing you of this offense. You give up the right to appeal. Once you plead guilty, you can never change this. Do you understand? One more thing is that if you're not a citizen, they can deport you, exclude you from the country, or deny naturalization. Once you plead guilty, you can never change it. Do you understand? Okay, how do you plead to the offense of evading arrest or detention? I will find you guilty. I'm going to follow the agreement. Be careful. Don't run from police again. Okay? All right.
Good luck to you, Mr. Edwin.
Look, Mr. Edwin.
You're getting out today. All right. Thank you, Judge.
Thank you, Laurie.
I'll follow this one now.
Oh, I'm filing it right now, Kelsey.
Oh, great. Thanks.
Hi.
Naval this morning.
Okay.
I was just appointed to the case. He has a pending assault family member in this court. I believe that you had asked that he be drug tested this morning, if that's
I
correct.
sent him for a drug
Oh,
test.
Come up, Mr. Venable, or Miss Venable, Mr. Venable. So we have him on an assault that's extremely old, and then he picks up an evading arrest in a motor vehicle. And the initial bond violation we have was
Failure to report.
it was a no-show at the scene. If you ever fail to show again, I will put you in jail. I will revoke your bond. Do you understand?
Sure.
Court orders are there for a reason, and when you no-show, that's not a good thing. We sent him for a test today, which is what we normally do, and okay, no more. You're not to use alcohol, illegal drugs, and I will test you 45 days from today. You test positive again for dope or alcohol, you will stay with me. Do you understand? I'm telling you now, you're going to get another test. So let's set it for 45 to 50 days. You must be here at the next setting and you will get tested again. You understand?
I have a question. My last,
We can provide you a lawyer. Your lawyer can answer the questions for you, but there's absolutely no tolerance. You have an open assault, now you have an open felony, absolutely no tolerance. You're a danger to my community. I only have one place for you.
I understand.
Okay, so we've given you a lawyer. It is your responsibility to stay in touch with her. If she tells you she can't get a hold of you because you're ducking and dodging and playing games, I will issue a warrant for your arrest. You pick up a third case, I will go nuts on the bond. Do you want to add anything?
No, Judge. For the court's awareness, he did have an open ABI that was dismissed because the complaint was since passed, related circumstances. This was an ABI, an old ABI that was still pending, then an evading.
Right. Right. And there's no tolerance. And so any more issues, I'll keep him with me. Okay. All right. Take a seat for me, sir. Thank you.
Judge, there's some conditions on the
Okay, hi, Sonia.
He's not here today.
What's the last name? Lintz, okay. I'm gonna revoke the bond, set it at 5,001 and then just, you want to stay on or do you want to withdraw? What would you like to? Okay, it's up to you.
I don't even have, like, I don't have a good number for him. He called me a couple weeks ago. I called that number to let him know about court and it wasn't working, so I don't even know that he knew to be here. And my guess is that maybe also why he didn't show up for the.
So I guess, I mean, if you tell me that, what I can do is roll it to Tuesday, you know, SF.
Set for bond forfeiture today because.
Right, I know, but you know, I guess what I would do for your CYA purposes is send a letter to the last known address. You know, there's contact information here. And just on the, whatever the bonding is, the paperwork, send a, you know, certified mail. We'll set it for a week. If he's not here at that point, I'm, you know, okay.
And then also, this off docket, but I do have the case number for you.
Okay. Okay.
So he has paid the restitution and completed his community service. I sent that to the state. They just need the signed contract so they can dismiss.
Okay.
He did get everything done.
Great.
Thank you for allowing him the rest of the week to finish the
Well,
PTO.
I mean, it's not dismissed yet. He still has to send the contract, right?
I know, yes, we just got that today because it was never put on the portal.
Great. Okay. Well, good luck. Just hopefully he gets it to you soon. Absolutely. You know, I don't want to have to put him in jail.
I know.
And I get, but yeah, I'm glad it worked out though. Hopefully he gets it.
I think so. I think he'll be good. So thank you for that.
Yeah, thanks, hon.